Good morning. Good morning, everybody. Welcome for the people that made it. I barely made it. Just get myself situated here. I'm only streaming to YouTube this morning out of precaution since I didn't have a chance to test out the connection. I think it was yesterday. It was acting up. But Mandy, thank you for the super chat. Good morning, chat family. Let me get situated here. We got the Supreme Court hearing today. Richard Allen. I sent myself this little video we could watch this morning as well. Let's see if I can find a live feed. If we're gonna get set up today. Okay, yeah, we have like 2 clips we can watch here. Good morning. Good morning. Okay, we got a couple people live covering it. I think Court TV, said they were going to cover it. I wonder if Law and Crime is covering it. Okay, we'll just wait for them to go live.
Heading to court later this morning as a hearing in his high-profile murder case begins.
And he's the man charged with the 2017 deaths of teenagers Abby Williams and Libby German in Delphi, Indiana. Kelsey's back with more on what we can expect from today. Hey, Kelsey.
Yeah, you guys, an Indiana law professor that I spoke to says that today's hearing is very unusual. Now, Richard Allen claims he's been mistreated. This comes after the judge just...
All right, let me bump the volume. We'll get into some of the details of Richard Allen. This gives us a little bit of a gist. There's 2 clips I wanted to show you guys. I also wanted to pull up my old notes. I was up kind of late last night. We had the chase last night, wild chase, and then I stayed up, I think almost 4 in the morning, setting up another desk and computer. But
profile murder case begins.
And he's the man charged with the 2017 deaths of teenagers Abby Williams and Libby German in Delphi, Indiana. Kelsey's back with more on what we can expect from today. Hey, Kelsey.
Yeah, you guys, an Indiana law professor that I spoke to says that today's hearing is very unusual. Now, Richard Allen claims he's been mistreated. This comes after the judge dismissed his attorneys. Now, Allen was arrested in 2022 for the death of teen girls Abby Williams and Libby German in Delphi, Indiana. Andrew Baldwin and Brad Rozzi were both appointed as his public defenders. But when crime scene photos were leaked from their law office, they were dropped from the case, and Allen was reassigned to new attorneys. However, an employee of their law office later admitted they took the photos without permission, and they were not leaked by Baldwin and Rozzi.
So somebody in the office took some photos and leaked it out. I haven't seen it myself, but there was this whole situation, and so those attorneys got dismissed. I guess Richard Allen wants his attorneys back. Now, Abigail at the time was 13. Liberty was 14. And this happened because the girls had a day off of school. It was a warm day in Indiana, 55 to 60 degrees. They asked Grandma first if they could go. She said they could go if they could find a ride. Older sister took them. I think they wanted to go they wanted to go hiking on this Monon High Bridge over Deer Creek. So at 1:35 p.m. on Monday, February 13, 2017, Abigail or Abby and Libby were dropped off at Jermaine's older sister, Kelsey Jermaine, on the county road of 300 North, east of Hoyser Heartland Highway. The girls were hiking on Monon High Bridge over Deer Creek among land in remote Deer Creek Township. At 2:07 p.m., Libby posted a photo of Abby walking the bridge. There's also a video too, I think. After this, they were not heard from again. They were reported missing at 5:30 p.m. after they failed to meet at Liberty's father's at 3:15 p.m. It took a long time for them to catch this guy. There was another article I wanted to pull up from Court TV I thought was kind of interesting. I'll look for it.
Now, Allen is requesting 3 things from the Indiana Supreme Court today. He wants his public defenders reinstated, the replacement of Judge Francis Gohl, and a trial within 70 days.
Given what we've seen so far, the judge will not be disqualified from this case, and Richard Allen has no right to have his original counsel reinstated. So the trial will move forward under Judge Gohl and with a new defense team for Richard Allen.
Now he also...
Yeah, so he's trying to get the judge thrown out, wants his old attorneys back. He's asking for a lot. And he wanted to reinstate the public defenders, set a speedy trial for within 70 days, and remove the special judge Francis Gohl and replace it with another special judge. So the previous defense team leaked crime scene photos, which the defense team is saying like it was somebody at the office. It wasn't like they planned it or something or whatever, and that person was let go. Before the removal, the attorneys asserted in court filings that Allen was living in hell. Now, this guy looks like he's in pretty bad conditions. Some might argue maybe they don't give a shit the conditions that he's in, but I guess that there's a whole process to the system. He did look pretty bad. He was pretty bad. I don't know. I should have probably looked for a previous photo. And they said he was living in hell in a protective unit at the maximum security Westville Correctional Facility. Pretrial defendants are typically housed in the county jail where the crime scene was committed, but after Allen's October 22nd arrest, then Sheriff Toby Lesenby asked the courthouse to put him elsewhere because Carroll County couldn't ensure his safety. The attorneys also saw a Frank's hearing accusing investigators of lying and misrepresenting facts in their affidavit for a search warrant for Allen's home. That search uncovered the only physical evidence linking Allen to the crime, a 6-hour pistol Allen owned that prosecutors say matched an unspent round found near the bodies after it was allegedly ejected from Allen's gun. Now, there was also, we always got to mix the cult in, right? There was a cult element as well. The attorneys asserted that members of a white supremacist cult who more likely killed the girls were also serving as guards in Allen's prison. Now, there was a guard that they said had some type of marking from that cult that was in that prison. I don't know if it was one or more. That was pretty interesting as well. And so Allen, he was a former CVS manager in Delphi, and he's accused of killing Abby and Libby while trying to kidnap them on February 13, 2017. The best friends were abducted while crossing this Monon High Bridge. I'll see if I can find I have this really bad quality picture I can show you, but we should look up the picture and the video, maybe some more news clips. Downloaded something here yesterday. I don't know where it's at. Well, now here it is. I'll get us a better picture though, and video in a bit. Oh, so Carrie in the chat says that picture looks staged to me. The way he's staring off in his hand, we're not falling for it. It reminds me of the that serial killer. Is it the Golden State serial killer? I'm thinking the right guy. Golden State serial killer. Yeah, Joseph James D'Angelo. So that guy was faking the funk too, because that guy, I don't know if that's really the case with this one, but that guy, let's say he was walking around doing all kinds of shit right before he got arrested, and then as soon as he gets arrested, all of a sudden he's in a wheelchair. Let me see if I can find you a video, because I was like, they had a video of him in his cell. Here we go. Here we go. Check this shit out. We got to look back at this.
As the Golden State Killer learned his fate today after a week of heartbreaking testimony from his victims. But is the serial killer really as frail as he appears to be in court? Prosecutors are now saying he's faking it.
Is the Golden State Killer faking that frail old man appearance? All this week, we've seen 74-year-old Joseph D'Angelo confined to a wheelchair.
All rise.
He sat disheveled and showed zero emotion as he listened to all those heartbreaking victim impact statements as woman after woman bravely faced him down.
He's a selfish, sadistic, calculating, cruel, pathetic piece of scum.
Michelle Cruz, whose sister Janelle was slain by D'Angelo in 1986, says his lack of reaction left her frustrated.
Didn't matter what I said, I don't think I got a reaction out of him. He just sat there and stared out.
Now prosecutors say D'Angelo is faking it. Sacramento District Attorney Anne Marie Schubert just released this video showing the monster springing up on a table in his cell to fix a light. Here, he's exercising, and here he's wiping the floor with a rag under his shoe.
Somebody said there's a method to his madness, and I think Mr. D'Angelo is very calculating and cunning and doing whatever he can, whatever's in his own best interest.
None of this comes as a surprise to D'Angelo's former fiancée, Bonnie Olson.
Yo, Rhiannon, I think that was the thing with this guy, wasn't it? He had a micro penis. Let me see. I think that actually is that why he did the killing and stuff? As I thought one of the victims actually described that micro penis. I know we're kind of drifting off a little bit, but I think we have some time this morning till they go live. Hopefully they go live. Yeah, it actually is a thing. Check this out. Thank you for bringing that up. Yeah, Golden State Killer had to sit there while most of ours made fun of his inadequate penis in court. 3 days have been scheduled for the victim impact statements in the Golden State Killer sentencing hearing. On the first day, defendant Joseph James D'Angelo, 74, had to sit there while the family members of rape survivors said he had a little penis. He is truly a monster with no soul, said survivor Patricia Murphy in a statement read by his daughter in court. Did his little penis drive him to be so angry all the time? Did he study criminology so he could carry out his evil deeds as a bad cop? He was a cop too. I forgot that. He was a cop without getting caught. Did his wife and daughter suspect anything? Wow. He punched me, broke my nose, wrote Murphy. I had a concussion from falling backwards and hitting my head on the driveway. I saw stars. I lost consciousness. She was diagnosed with post-traumatic stress disorder. Wow. Yeah, this guy was truly sick. All right. I wanted to play another clip for you guys. I haven't watched this one yet. I'll watch it together.
And for more on this now, to give us some more insight in today's hearing, is Brian Claypool. He's a criminal defense attorney and legal analyst. Brian, thanks so much for taking the time this morning. This is being taken up by the Indiana Supreme Court today, obviously the state's highest court, months before the scheduled trial in October. How unusual is it for the state's highest court to intervene like this in this case?
Hey, Marky, good morning. Great to see you. It is highly unusual because usually in criminal cases, you have appeals heard after there's been a verdict in a case. And this is an appeal that's being heard before the trial starts. So it's extremely...
Wait, okay, let me see. Are they live? Are they live with this now? I don't see it yet. Okay, Court TV has it actually somewhere. I wonder if this is oh no, let's see. Is this the website? Court TV. Watch live. This might have been this morning. Let's see if we can take a look at this. This might be them kind of doing something. Watch live. Yeah, I think this might be it. Well, let's watch this in the meantime. Looks like they're kind of doing something. I don't know what this is. So I can find.
Skull removed them for gross negligence after leaked crime scene photos were linked to Andrew Baldwin's office.
Journalism. It's time for you guys to start being journalists.
Before their removal, Rosie and Baldwin asserted in court filings that Richard Allen had been living in hell in a protective unit at the Westville Maximum Security Prison. They also accused investigators of lying to obtain the search warrant for Allen's home. That search warrant uncovered the only known physical evidence linking Richard Allen to the crime. That evidence, a Sig Sauer pistol found in Allen's...
I need to find a link. I don't know how they're streaming this shit. This is not the link. Let me see, Richard Allen. Okay, there's a website. Let me try this one. Watch live. Click here to watch arguments live. Oh, here we go. Oh, yeah, I didn't know the inside scoop. Everybody else knew it. I didn't know it. Okay, I found it. My bad,
there's
guys.
A conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes, and when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial was...
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the...
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But, Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive what concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
That's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things, and Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth Amendment
My concern is
requires.
getting this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge that there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's a structural error, and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
There's a lot of events in this case that led up to that hearing, correct, with regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're not
Filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest and says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel,
last name Slaughter,
and Mr. Allen's convicted,
poor judge,
can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection, I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can say, let's have a hearing regarding that pretrial publicity and somehow establish that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did?
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that would constitute ineffective assistance of counsel for a Sixth Amendment violation, so if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason, that there's an intimate relationship going on, and she pulls them in, goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, in that case, it'd be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear. Nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent that from happening?
I think if there's a concern, say for example the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
structural error,
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice-only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October, and when the judge said it in October of 2024, one of the lawyers, I believe, even represented he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for three reasons. First,
representing the judge?
The trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance of counsel.
But I'm really struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice. That's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So tell us why you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel, and on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process, and the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
and just
violation.
So I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be...
But it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on, I think you're incompetent, and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed? So, which means
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective.
Tell us.
What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys, and so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, in the Wheat case. I don't see Wheat as tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based on
where can you point to me saying, with regard to saying somebody is incompetent or negligent, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is, under U.S. Supreme Court precedent as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that's the problem. Issue is, I would say,
speedy trial,
not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, you know, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
that
this.
Protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr. Gutwein. Ms. Sanchez.
Ms. Sanchez, a teammate, back team. I think they're going to lose the speedy trial thing, but he might get his attorneys back. I don't know.
There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interests, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front end of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands, is of course secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence,
my body, my choice. Y'all should be flexing that shit. Yeah?
And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case, and then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly significant,
the default rule,
weighted,
something like it.
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in
But for these reasons, it could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular things cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Well, tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
Saved by the bell.
Saved by the bell, exactly. She was looking at that shit.
Well,
I guess that's a big
no
ass
one wants
red
more
light,
proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action.
Yes.
Whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel.
That's the attorneys for the judge, I believe, representing.
Am I at 7 minutes now? We don't know. All right. I'll go.
I'm going to read an article. When they pause, if they do, I'll read an article.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen, and because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing, here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what Wheat gets clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So My troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration, and we ask you to grant the relief we requested. Thank you very much.
Oh, okay, so the lights up yellow right
I
before.
want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
Okay, nice. So, do they just like hold and wait and to decide now, or is it like, I guess they decide now? I think the attorney representing Allen did really good. I don't know about the speedy trial. Are they leaving? I don't leave me now. Roro, thank you so much for the gifted memberships, 5 memberships. Also, Heather K, thank you earlier for gifting 5 memberships as well. We'll leave this up and see. Oh, I guess they ended it. How does this shit work out? When do they decide? Do they tell us at a later date? That was pretty interesting. Kind of hot. I wanted to go over a couple articles, kind of to explain a little bit. I didn't do a good job at all when I first started the stream. I wasn't really prepped. I should have started out with this article, but this kind of breaks down a little bit of what's happening. I feel like, I don't know, I'm no expert. I almost feel like maybe they'll rule to give him his representation back, the people that he wants, those 2 attorneys. I don't know how the speedy trial is going to work because they didn't file it within a certain amount of time, I believe. So I don't know if they're going to go back on that. Let me refresh this and see. Yeah, they close it out. I guess that's it for that. Man, I want to know. I'm so curious to see what's going to be the outcome. Let me read you this article by the Indy Star. I think it's a local newspaper. So, Delphi murder suspect Richard Allen has the autonomy to choose his own representation, and Special Judge Frances Gull exceeded her jurisdiction when she disqualified Allen's court-appointed attorneys. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objections based on her subjective belief that Allen's defense team has been grossly negligent. Mark Lehman, who represents Allen in the Indiana Supreme, argued. So that's the guy that we were just seeing. The Indiana Supreme Court is hearing testimony this morning on Allen's request to reinstate his former court-appointed defense team and remove Gull from the case. Get her out of here. Matthew Gutwein, who represents Gull, argued the judge had this discretion to disqualify Allen's attorneys. He also argued that the regular appellate process, not the Indiana Supreme Court, is the right venue to resolve Allen's requests. And Angela Sanchez, Chief Counsel of Appeals for the Indiana Attorney General's Office, also argued that the regular appellate process is the right avenue. There's nothing clear or absolute about this case. There are means through the trial court and the appellate process to untangle complicated questions, twists and turns of the Delphi murder case. And we got to talk a little bit about this. I want to play some clips, if I can find them, with the whole weird cult situation. The dispute before the state's highest court is among several controversies surrounding one of the most high-profile murder cases in Indiana. Allen is requesting the Indiana Supreme Court to reinstate his original defense team, Andrew Baldwin and Bradley Rozzi, whom Special Judge Francis Gold disqualified from the case after finding they had been grossly negligent, and they're going to explain why. They're talking about that whole crime scene photo that was leaked. Allen is also asking the high court to remove Gold from the case, arguing she had shown bias against the defense, and to set a trial date within 70 days. Wants to get this thing started. Let's go. Allen is awaiting a trial for the killings of Abigail Williams and Liberty German, 2 teenagers whose deaths captured the world's attention. The friends who were last seen on February 13, 2017 on the Monon High Bridge in Carroll County were found dead in a nearby woods the next day. Allen, who worked at the local pharmacy, was arrested and charged more than 5 years later. The controversy surrounding the case have spawned a circus-like atmosphere that legal experts say are threatening to overshadow the memories of the 2 slain teens and derail Allen's right to a fair trial. I think just like trials and murder cases and like jury is getting more complicated as, I don't know, true crime grows. I think it just, everything is just the internet, everything's online, public conversation, public discourse. Is this the actual CVS? It's a nice CVS. I like extra CVS. I don't like CVS personally. I used to work there. I worked there 5 years. I'd rather go to Walgreens or go to Publix. They never have nothing in stock. Prescriptions always take forever. I don't know how it depends what Walgreens you go to too, but like CVS is just like the worst. Anyway, here in Florida, it's the worst. Evidence leak leads judge to remove Richard Allen's attorneys. The legal wrangling now before the Indiana Supreme Court stems from a leak of graphic crime scene photos last fall, just months before the case was set to go to trial. Court records show a former employee of Baldwin's had surreptitiously, that's how you say it, taken pictures of the images he had found in a case file at Baldwin's law office and sent them to another man, who then forwarded the images to someone else and later offed himself after police questioned him about the leak. Why would this person off himself? Is this another mental health thing? Is there mental health behind it? I mean, were they just afraid of the repercussions? Oh, I never understand how some people. I mean, how much jail time could have really done for that? I mean, I know it's a serious. What do you even do jail time? Maybe do jail time. I don't know. Possibly the Church of CVS, Odinist CVS. Daybell now. Is there a live stream going on right now for Daybell? Hold up. Chat Daybell. Those people, what state are these people in? Lori Daybell, that state, they take forever to deal with crime. Oh yeah, he's in court.
From the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your
Honor. You guys want to do chat Daybell?
Today.
Okay, thank you. And they're doing construction.
It actually just started. All right, let's finish this article and then we'll do chat Daybell. You guys tell me in the chat if you want to do chat Daybell. Let me just finish reading this last part here, and then we can play it on fast forward. Idaho, yeah, they take forever to prosecute crime. Jesus Christ, over here playing games. Everything's like, it's one of those states where like they do. I'm trying to think of the right verbiage. They do sentencing like way later on, right? I feel like Lori was like all this bullshit of like, all right, we're gonna come back later on, and then we're gonna come back later on for another thing, and later on another thing, and another thing. Like they take forever to do shit. So this guy offs himself. All right, the leak and the unaliving set off a whirlwind of activity, including a private meeting in October during which the Goal told Baldwin and Rosie that she found them to be grossly negligent and incompetent. She enumerated a litany of concerns, including the leak, and told attorneys that she intended to read them in open court. Baldwin and Rosie then decided to withdraw from the case, with Rosie saying the judge left them with an impossible choice: quit or be shamed publicly. Also, they felt like forced. But now they want to come back and fight. But the attorneys later backtracked and insisted on staying on Allen's request, even after Gohl had appointed new attorneys to the case. Gohl removed the attorneys during a contentious hearing in late October. I cannot and will not allow these attorneys to represent you with the concerns that I've had, Gohl told Allen during an October hearing. Okay. All right, let's do some Chad Daybell. You guys want to listen to that? Chad. He's a Chad. All right, Chad Daybell. We didn't even do the cult stuff too. Maybe at the end of the stream we'll cover a little bit of the cult stuff with Richard Allen. So Chad Daybell, he's charged with the first-degree murder in the death of Vallow's children who once lived in East Valley. We haven't really covered much of Lori Daybell. Didn't they dub it like the cult mom or whatever? Or he was actually the cult leader, wasn't he? And she got into it. They caught her ass. I forgot what country it is. They caught her ass sipping on a margarita after the murders and stuff. So he's charged with the murder and the death. Oh, I didn't know they were charging with of Tammy's death. Wait, he's charged with the murder and the death of his first wife, Tammy, and in the death of his wife, Lori Vallow Daybell's children. Okay, yes, and Joshua JJ Vallow, which was 7 years old, and then Tylee Ryan, 16 years old. He's also charged with conspiracy to commit murder in all three deaths. And this is the one where, is this the case too where one of the family members or something died on the toilet? The hitman or something? The people that suspected. I don't know if I'm thinking of the right story.
Proceeding will be on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Scheduled
right?
This morning is a hearing on defense counsel's motion to withdraw. A couple of preliminary matters before we get started here. The court will note there is an order governing courtroom conduct. The court is live streaming this on the official YouTube channel of the Idaho Supreme Court. I'm not permitting any other recording, video, or audio of the proceedings. So if you have a device that does that, that's not permitted. In addition, if you do have devices that make noise, please make sure they're silent or turned off to not disrupt the proceedings. And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then yesterday on the 17th of January filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copy today. Already had the court's order unsealing the August 25th from last year order and a copy of that order.
Yes, Your Honor, they were provided to counsel today.
Okay, thank you. And they're doing construction right through the doorway here, so counsel could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here.
Mormon carpet.
Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today? Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit arguments in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well, and that I should probably, and is my voice at this point acceptable, Madam Clerk? In terms of the tone, it's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors, and got the idea of maybe reaching out to out-of-state attorneys, and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with.
So what's going on here too is that a hearing that's being held today on a motion to withdraw as counsel filed by Chad Daybell's attorney last week. John Pryor filed the motion because he says he isn't qualified to argue a death penalty case and his client can no longer pay him. Pryor has been Daybell's defense attorney since May 2021 after a grand jury indicted Daybell and his wife, Lori Vallow, on murder and conspiracy to commit murder charges for the deaths of J.J. Vallow and Tylee Ryan, two of Lori's kids, and Daybell's first wife, Tammy. Chad Daybell is also charged with 2 counts of insurance fraud in relation to Tammy Daybell's life insurance policies. Prosecutors filed a motion Wednesday opposing Pryor's request to withdraw as counsel. Jury selection for Daybell's trial is scheduled for April 1st. Okay. So that could probably delay things, obviously, I guess. The hearing is being held before Judge Stephen Boyce. Okay.
With him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to, appoint an attorney. Mr. Daybell has private counsel, and I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So,
right, and that's correct, Judge.
This is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously,
how don't you need the money, though, if you're going to put in all this work? Maybe Woody, thank you so much for the super chats. Thank you for the 5 says. Love you, Lutfi. Peace, love. Thank you for being you. Thank you for the other super chats, Natalie, Vic, and all the good ones here. Thank you, Lutfi. Hi, Mel. I have greetings to our mods. Thank you. And Mimi Moody says, love the bacon, margarita mods. And Mandy, thank you so much. Loving the attorney's strip socks, shoes.
obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do.
Just say it.
Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get.
Is there any kind of situation where like the judge can be like, okay, you're going to get paid by the state or something? For that kid, that doesn't happen, right? Would they have to give him an appointed counsel? Like, how did that work? If they, I don't know.
Get paid for the work that I do, and that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue, because that is a trial issue, and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in a public proceeding. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security.
Okay, so we're behind on this too. So we can fast forward. I don't know if they came. Oh, they haven't come back yet. Okay, I fast. So we're caught up now. They're having their private session. Thank you. I just want to give a special thanks to all the members too. Dreamers, thank you for the 2 months. Says he would never been found had they not recorded. Arkansas, thank you for the 19 months. Says, good morning, Mel and chat. Thank you so much for resubscribing all those months. Appreciate that. Katrina Hetherington, thank you for the 3 months. Patrice Change, thank you for the super chat earlier. Congrats on 200K. Thank you. Servant of God, thank you for the 15 months. Bye. Congrats on the 200K. Thank you. Patrice, thank you for the membership. Edit Twins, thank you for the membership. Mandy, I got that already. And Mimi Moody, thank you for the 13 months. Appreciate that. Amazing. So Kelly in the chat said he sucked the private attorney's money out of Chad and now pulls out right before the trial for a reason. That's kind of dirty. That is kind of dirty. Because the trial is set to start for April, and the judge has like this tough decision, I guess, because if he has to get appointed new attorneys, I'm assuming that's going to set back the trial. You know? Now, the Odinists, Richard Allen. We can take a look at this real quick. I don't know how long they're going to take, but we can take a look.
What's going on in Delphi, Indiana? Now, for those who don't know, Richard Allen has been accused of murdering Abby and Libby. It was a case that was cold for 5 years. There were lots of suspicious people, lots of rumors, and ultimately some guy who wasn't even on the radar who works at CBS in the film developing department ended up getting arrested for the murder. Then we learned a lot more when the defense filed some documents last week. I want to go through really the headline, right? So he's accused of murdering these two girls. They believe they have some forensic evidence involving a bullet. They have an admission by him and some other things, a couple other things. Not a ton of evidence in this case, but they have some eyewitnesses, etc.
They had an admission by him? I didn't know that, did they? Alan?
Etc. So they have put forth a completely different look or different story about what actually happened to Libby and Abby. They're not saying there's not evidence to prove the case.
So documents reveal that, among other things, Allen admitted to his wife during a phone call that he was responsible for killing the teens. Interesting.
They're saying he's innocent, and we know exactly what happened to these two teenage girls in the woods on that day in Delphi, Indiana, near the Monon High Bridge. So take a look, because I'm going to lay it out for you, and it's really a two-pronged conspiracy. That's the gist of this. And it begins with members of a pagan Norse religion called Odinism.
So what do you think about this Odinism stuff for the people that have been following this case? Just a bunch of BS? I mean, there's the Odin prison people there, I guess.
Hijacked by white nationalists, ritualistically sacrificed Abigail Williams and Liberty German. Odinism is the pagan religion referenced above, and its followers are called Odinites.
Odinites.
Odinites or Odinists here are enamored of the Viking Nordic culture. Evidence supports that at the crime scene, these murdering Odinites left behind obvious signatures, symbols in the form of runes. These runes were formed with sticks, fashioned with tree branches, and painted using the blood of Liberty German. Sticks and tree branches were deliberately and carefully, proficiently placed on each girl in a certain arrangement mimicking certain runes. At least one of the branches appeared to have its end cut off cleanly by some type of tool, like an electric saw, providing proof of a preconceived plan. Additionally, the blood of Liberty German was used as the paint to mark a tree with a rune that looks similar to the letter F. With a simple Google search, these runes would be identifiable as one of the many calling cards of this pagan religious cult. Okay. They also described the scene where Abby and Libby were murdered. With that information, we put together this graphic. This was not something that they created. We created this based upon their description of what Abby and Libby looked like. And the allegation is that the bodies were posed and these sticks were put in a very specific manner to send some sort of a message. And there was a tree with a marking of what they said was an F. Now, that's the first prong, okay? Is that the Odinites are responsible for the murder in the woods. This ritualistic sacrifice in the middle of the day. I mean, middle of the day. It's not a nighttime ritual. This is a ritual in the middle of the day. Now, another piece of the prosecution case against Richard Allen is that he confessed. Take a look. On April 3rd, 2023, Richard Allen made a phone call to his wife, Kathy Allen. This is when he's incarcerated after being arrested. In that phone call, Richard Allen admits several times that he killed Abby and Libby. Investigators had the phone call transcribed.
So while he's incarcerated, he calls his wife and tells her over the phone. That's kind of weird. I'd be interested to hear that call.
And the transcription confirms that Richard Allen admits that he committed the murders of Abigail Williams and Liberty German. He admits several times within the phone call that he committed the offenses as charged. His wife, Kathy Allen, ends the phone call abruptly. Big part of the prosecution case. You get arrested, you make the phone call, everything's recorded, it's monitored, and in this case, they're saying he basically spilled his guts to his wife.
Hoke said with a CO right behind him. That is weird because everybody knows that those calls are recorded. I mean, I think they even tell you or something, right? It's something like some type of automated thing. They all know it's recorded.
Wife. Now, take a look at part 2 of the Odinite conspiracy connected to this case involving Richard Allen, according to the defense. Normally, corrections officers were within earshot of every conversation between Richard and his attorneys and between Richard and his wife, close enough that Richard would have to be worried about any conversation with his attorneys and with his wife being overheard by corrections officers. Corrections officers even required that Richard Allen be positioned facing the window where the corrections officer was videotaping the attorney visits with the handheld camcorder. This positioning of Richard Allen's body would allow the corrections officers to videotape Richard Allen's mouth as he talked to his attorneys. This is the key. Richard would therefore not be able to privately discuss anything with his attorneys, such as, and this is the quote, "The guards are telling me that my wife and family will be killed unless I call my wife and tell her that I killed those girls."
Wow.
Okay? He is alleging that the guards were threatening to kill his wife and family unless he called them to confess. Why is this significant? Because the defense is also alleging that these patches, the triangles, in Odin we trust, were on the uniforms of the corrections officers.
I heard about that, yeah.
You're following that? Those patches on the corrections officers, meaning they're Odinites. The two prongs, again, of this conspiracy alleged by the defense. One, the Odinites sacrificed and murdered these two girls in the woods, down the hill from the Monon High Bridge in the middle of the day. And then when he was arrested and incarcerated, he's being guarded by Odinites, who then threatened to kill his family like they had killed, I guess apparently, Abby and Libby, unless he confessed. They were framing the guy who develops pictures at the CVS.
Wow, this is crazy. I don't know, man.
The defense.
This is wild. I don't know, man. I did hear, like, I thought they, somebody did get, like, a prison guard that had that Odinite thing got fired or let go. Odinist prison guard. Let me see. But I got fired. Maybe not. I thought I read that somewhere or saw it somewhere a long time ago. Yeah, look at this. I thought it says here, I don't know what Daily Montana is, but corrections officer with alleged ties to white nationalist group no longer employed at Montana State Prison. Oh. I guess that's different.
Let's bring it.
Moody, thank you for the 10. Gracias. Thank you so much. You, Mel, Luffy, and all in the chat. Great to be a member. Thank you.
The think tank. Can that be sold in court? Joining us in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III. Also joining us in Stamford, Connecticut, criminal defense attorney Darnell Crossland. And in Cleveland, Ohio, retired judge, former criminal prosecutor for Cuyahoga County, and judicial fellow at the National Judicial College, Judge Gail Byers. Great to see everyone tonight. Al, I'll start with you. Wait, first, just a show of hands. Don't say anything. Before this, has anyone ever heard of Odinism? Okay. I'll see everyone again. Before this, has anyone ever spoken to an Odinite? Oh, he's pointing at Al. You got to point the other way, Darnell. No. You haven't spoken one. All right, Al, let me start with you. Can this thing be sold in a courtroom? Does it make any sense? Now, we've prosecuted, I mean, we've seen cases where these crazy conspiracies are prosecuted, like the Doomsday Cult Mom. So I know cults and strange beliefs actually exist, but to this extent?
Well, what's interesting to me is that this so-called cult, okay, worships Odin and Thor, okay, and Loki, okay, so we have like the rest of the Marvel comics going forward here. It is a religion or a movement that was sort of adopted by the Nazis, and it is a white supremacist group, okay, that has kind of taken over on it. Now, you have a scenario here that, in Oslo, they had that man that went into the camp and killed all those people. He claimed he was an Odinist and that he was doing it for that purpose because he was an Odinist. But I can't imagine that a white supremacist group would kill two young white girls. So, I mean, it seems odd to me that if you're going to be a white supremacist group and you have a belief that the whites are superior and that they should not be mixing races, then the last thing you're going to do is kill 2 white young girls who could grow up to produce other Odinists and other neo-Nazis.
That's a good point. I just joined in, but that's a good point.
So it doesn't make a lot of sense to me. And with regards to the fact that the guy is a photographer, you know, he works at the Walmart or whatever.
CVS.
Photos at CVS. Okay. We all saw the movie, you know, 1 Hour Photo, Vin. So it could be actually something that could happen.
All right, Darnell, what's going on in Delphi, Indiana? Now, for those who don't know, Richard Allen has been accused of murdering Abby and Libby. It was a case that was cold for 5 years. There were lots of suspicious people, lots of rumors, and ultimately some guy who wasn't even on the radar who works at CVS in the film.
I started over by accident. Oops.
Is this something that you would be comfortable presenting to a jury? Now, they name specific names as well in the papers. We have not repeated those names on the air, but there are specific people they are going after here. Now, the motivation for these white nationalist Odinists was that apparently, according to someone somewhere, is alleging that one of the girls' mothers may have been dating interracially.
Okay. Well, the first thing I just wanted to request, since we have the honor of having a judge with us today, if Al talks too much, can the judge hold him in contempt on the court TV?
Absolutely.
You know, I'm much like the Odinists. I'm going to start drinking mead every time we have Darnell speaking. That's the only way to be able to tolerate it.
So, Vinny, I think, you know, the funny thing about whether I'm comfortable defending this case is that it sounds like when you take away the Odinist and, you know, all that other stuff, it sounds like the defense is, I didn't do it, someone else did it, and here's the evidence. And if they're saying that there's evidence, DNA evidence or trace evidence of blood or
no, they're saying there's sticks. There's a bunch of sticks that are aligned a certain way, and the prison guards are Odinists, and they come.
Oh, no, bro. It sounds kind of crazy. That was a little nutty to me. I don't know. So it's still a court break. A little weird, right? A little awkward. Let's see. Oh, I ripped a piece of it. No. I wanted like a nice color to add to it, but I got another one coming in today. It's like a green one. But this one's just doesn't fit right. It's actually made for the other microphone, but I thought I'd be able to get it on. The Zoom thing is not back yet. We're watching right here. Buffering. There's no buffering on my end, boo-boo. Everything is A-okay. What time it is? 12:52. All right. So while we wait, let's close some of the stuff out here. The hundreds of windows that I have open. Richard Allen.
We're linked to Andrew Baldwin's office.
I ordered this Ridge wallet, and I'm actually unimpressed by it. I wonder if I can return it to them. It holds my cards better, but like, they don't actually have a function to like pull the cards out. It's just you just press down, and then it's like a little. Then you have to still separate them. It's kind of lame. This other one does it better. You just push the button, and it pops open. Bloop. All right, let's see. Inside Edition. What's going on in the world? What's going on in the world today? Woman calls 911 after suspected burglar attacks her mom.
A suspected burglar cases a house. Then he goes around back, where cops say he shattered this back door and broke in. But he didn't expect this. Mom comes home and chases the guy out of the house, slamming him to the ground. Mom won't let up, kicking the suspect in the leg and screaming for help. Then he body slams Mom to the ground. She won't.
A weird ass guy too. Look like a
won't back down. It's a wrestling match for the ages. Mom believes that backpack is loaded with stuff he stole out of her house. Look, she won't let go, but help is on the way.
Mom, you okay?
Yep, it's her daughter's voice coming out of nowhere. She's watching the struggle unfold on their Ring camera from 17 miles away while at work. She calls 911.
Yes, I am at work and my mother just got home and she got attacked.
You said she got attacked?
Yes.
By what?
By some man on my front porch.
And there they are, Mom Christina Byers and daughter Shannon, safe in their home in Bethany, Oklahoma.
I was just scared. Honestly, I was just like watching it going, I really hope she's okay.
Turns out Mom is a retired sheriff's deputy and knew how to handle herself in a crisis.
I wonder she was throwing down. I was like, then she willing to die for the household items.
Was not going to leave with that backpack that he had on because he had been in the room where my weapon was. I didn't want a gun out on the street.
That explains why she was so aggressive about tackling him.
That man's just yelling at me, lady, let go.
Police nabbed the assailant a few blocks away. Check out those bruises on his face. Lesson learned, don't mess with Mom.
Man.
Well, it turns out.
Amazing. Dog named Bob fights back during lake rescue.
He's in the ice.
Bob the dog needed some help, and Utah firefighters came to his rescue.
Bob, be nice. He's gonna help you.
Bob normally loves the water, according to the North Davis Fire District, but the large shelf of ice prevented him from being able to get out after his polar plunge. Firefighter Logan Hadley took on Bob's normal stance and got down on all fours. He crawled out on the delicate ice.
Bob, be good. Okay, go get my Cheetos.
The frightened and likely freezing dog wasn't so sure about the help coming his way. Hadley entered the water backwards and made contact with Bob.
And
there you go.
Bob.
Bob, it's okay.
Okay, good. Good job, good job.
Bob, no.
Despite pleas from his human family, the confused dog started to fight off his rescuer.
He's trying to bite his face. Just give him.
Hadley gained enough control to hoist the big dog out of the water.
I just said, fine, stay.
Then
What
the firefighters brought them both in.
Pull, guys, pull, pull.
Firefighter Hadley and Bob the dog are both doing.
We need a status update on the dog. How's Doggy doing? Wonder if there's any updates on a story we covered yesterday or last night. The guy that shot and killed 4 people, I think, including, and then himself 5. Okay, we are live. What's up, everybody? What's this guy's name? I forgot his name. Okay, Alric Alfonso Barrett. Let's check out and see if anything else came out of that. Or bend. Oh, by the way, we don't have a huge amount of people here, but make sure you subscribe to the second channel, trying to get the numbers up. So eventually we can hit similar numbers on both channels as far as live viewers. So if I have to go live over there, I have to go live over here, blah, blah. The backup or the second channel, whatever you want to call it. Doesn't look like there's anything new on this guy. Two children hid in the closet while this guy did what he did. Let's see if anybody on Facebook's talking. Oh, actually, somebody commented on my live yesterday about this guy. Not on my live. After I posted the, I think did we pin it? I thought somebody had said they were like a friend of his or something. They used to work together. And he was so nice. I thought it was for that video. I don't see it. Maybe it was a different video then. Oh, nothing. Very nice. I can save this for later. Okay, let's see. Any Savannah updates? Probably not. Oh, there's something we could talk about. I was actually thinking maybe doing a live stream about the Kansas City murders. Kansas City fans found in scientist's backyard. What they say? They say they froze to death. What were they doing? They were partying or something, and then they couldn't find them after, and then they found them in the backyard. I think we could do a separate live stream on that and talk about that. Let's see if the church has said anything else about me. They tagged me yesterday and a couple other YouTubers. The church. Battalion. Okay. Ooh. We're still going in on those victims. Oh. Mimi Moody says 3 boys and husband hungry, 7 p.m. in CH, time to eat. Where's CH? Oh, Chicago? No, Chicago. It won't be 7 p.m. in Chicago. Where's CH? Where's that at? It's another country? Not another country. Oh, maybe you're in another country, right? Where's CH at? Yeah, I'm about to go get something to eat, man. I'm hungry. Switzerland? What? Yeah, the one story. Yeah, the guys who mysteriously died watching a football game. Yeah, I heard about that. We might cover that later. I was thinking about doing it tonight or something. I just want to fly. Put your arms around me, baby. Put your arms around me, baby. I just want to fly. All around the world, I was all about today. I don't know. I think I'm gonna get something to eat. I don't know if I just leave this up. Just let it see when they come back. I am curious to see what they have to say. I don't want to like end the stream and waste a notification going live later to update it. I could just leave it. Get a little something to eat. And a little bit I'll have to go pick up the baby. Walkabout Bridge. I don't know if you're still in the chat, but thank you for yesterday's super chat. I'm sorry I forgot to read it last night. Oh, they're back. I'm in Florida and it's freezing. Love you, Mel. You must be up north. It's been kind of cold and murky lately and dark and depressing out there, but the chat screen. All right, what's the temperature right now?
Please be seated.
It's 80 degrees outside now. I'm going to grab a little something. I'll be right back. I'm going to use the bathroom. Be right back.
All right, we're back on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions. One being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit and motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case, and as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying, I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is, I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed, and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for the argument and response, Mr.
Judge,
Blake.
could I respond briefly?
I was going to allow your response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money, and I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the workload.
You've been on a case for 2.5 years by yourself, and all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law, and the way the law is written, and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognize, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated, is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly. All right.
All aboard. So the Chad Bell's attorney was kind of snapping. Yeah, I got 6 attorneys. I got all this shit. I got unlimited funds, all that by myself. Popping. I think it was a little bit dirty right before the trial in April coming with this crap. But I don't know. The prosecution does have all these people. I mean, I don't know how all that stuff works. Got 6, 7 attorneys, unlimited funds and shit. You over here working for free. Oh. Or he was. I mean, he was getting paid, I guess, before, but now he doesn't have money, I guess. Chad. It's a weird thing because then what? I guess you just force him, right? You force him to work. You can't leave. You can't go anywhere. You have to stay and represent him. And then can Chad say he didn't have an effective counsel? And it's a 2-month trial, he said. Oh. You want to do a vote? Pookie, hey, Pookie. Well, let's have a vote. Will he stay or go? Will he stay? Okay. Chad's attorney. Forced to stay. Let go. Is the attorney pulling a stunt? I wonder how people fall into cults. I guess it's like a variety of reasons, probably, right? Things going on in life, I guess. Mental health. Maybe it's like another form of religion. Going to God, getting attention and love, and somebody you can just trust in. Chad Daybell.
News in Chad Daybell's case as reports are coming down that the prosecutors are objecting to John Pryor withdrawing as
Let's lawyer know.
Chad Daybell's attorney. It's a risky move since he's not death penalty certified, and that could create potential appellate issues and counsel competency issues if Chad Daybell no longer wants him as his attorney and they've agreed to appoint 2 death penalty certified attorneys for him. But the state is probably a little annoyed that they've waited this long when this problem has been brought to Chad Daybell's attention numerous times throughout the process, and they do not want to cause another delay. The hearing is going to happen today, and we're going to find out whether or not John Pryor is allowed by Judge Boyce to withdraw as Chad Daybell's attorney. Not quite, but close to on the eve of trial.
Man. Wild. It's Rico Suave. So yeah, I don't know. Put your votes in. We got 124 votes. 65% say forced to stay. 35% say let go. Let his dirty ass go. Where's Mo? I don't know. She might be working. She's working her dream job. Let's see, Court TV. Oh, him and his wife were charged with murder. Oh, Karen Reed case hearing. Oh Lord, there's something coming up today too. Karen Reed. Motions hearing. Oh, promotions. Okay, this is supposed to be. That's coming up later. Motions hearing on Thursdays is expected to address a request by Karen Reed's attorneys to release letters from federal investigators to the public. And this is a story that has a lot of controversy. A lot of people on the internet fighting, going back and forth about what they believe happened. I haven't gotten into this. I've seen it. It's kind of messy. Sometimes you got to throw yourself in the mess. It says Reed is accused of murdering her boyfriend, Boston police officer John O'Keefe, whose body was found in the snow outside of the fellow Boston officer's home in Canton, Massachusetts. Prosecutors have said Reed hit O'Keefe with her car and left him for dead in the snow. But Reed's defense team has said she's never hurt O'Keefe and she's being framed by the true killers who may have been inside the house where the body was found. Maybe we need to get a little bit messy and dirty. Throw ourselves in the loop of the mess, drama, the fights, and the bickering amongst fellow online. Well, I'm not going to bicker with them. I'll bicker to myself, though. There's a large group of people that feel she's innocent. Karen Reed. Maybe we'll check it out later at 2:50 p.m. I'll be back. I think I'll be back home by then. I don't know. Have you dabbled in any of the hydro systems for plants yet? No. I haven't. What's that? Maybe we should get in the mix of the dirt. Find out what's going on. Karen Reed and Turtle Boy. Is he still locked up? I don't know if they let him out or they put him there with no bail. Please don't become a turtle rider. What's that? Still in jail? Well, I don't know any of the real aspects of the case. I mean, we could come later and watch the hearing and then maybe do live streams later on looking at some of the court documents and stuff and evidence and whatever else. I don't know. We could do whatever. So many things we could do. That's what I was wondering, Lisa, if they force him to stay. At least this judge is going to make a decision now. I have to leave in about 10 minutes. I'll probably just leave the stream running when I dip out. Just to go pick up the baby. Jamie, thank you for the super chat. I'm to get myself a little salsa water. Thank you for the 20. Says, hi, Mel. Karen Reed is innocent. The case is rampant with corruption, and I'm emotionally invested. Much to my charging. Aiden Kearney is basically a political prisoner jailed for uncovering massive corruption and blatant cover-up. How many charges did they charge him with? Aiden. Ooh. Mr. Brown said, I sent you a hydro system, a cool hydro system for the kitchen to Amazon. And Amazon. Okay. Instagram. I'm going to check it out. I want a hydro. That sounds cool. I want a hydro system. When's the Karen Reed trial happening? Is there a date set yet? Oh, that looks gangster. Was that weed or something growing in the kitchen? Hold on. Hey, that should look crazy. Is there a lot of maintenance and stuff, or do I just push a button? That should look gangsta. Let me show you guys. On some Breaking Bad shit. Oh, I could even get it today. Between 5 and... I don't think I should order it yet. I think I should do some research. Wow. I do hydroponics growing system kit. 12 pods indoor garden with LED grow light. Loved gift for green thumbs. Christmas built-in fan. Auto timer adjustable height for home office. So, I mean, does this come with the plans, or it just comes with a device and then you put in your whatever plants you want? I want something exotic and poisonous. Putting you on headset. Oh, I gotta wash dishes. Cool. 19 felonies now? Holy moly. Jesus. And he has kids and stuff too, doesn't he? I thought I saw like a post where he said I think he got arrested in front of his kids. That's kind of sad. But he's been I don't know much about him. I've heard of him. I've known about his website for a long time. I didn't know he had like a YouTube page and all that. The Turtle Boy. I've seen his website before. And and he has a lot of support because I think I've seen they were doing like protests and stuff. I really would have to, before giving an opinion, I'd want to see those documents and kind of go over the story a little bit. I don't know if I want to delve in. I feel like we need to delve into some. I mean, we have a lot coming up. Next month, we do have Harmony Montgomery. I mean, it wouldn't be hard to kind of follow up on an extra story on the side. I mean, Harmony Montgomery is probably going to be pretty consuming, but like right now, because we're done with the Savannah story, I feel like we're going to have to get into another story. It doesn't have to be immediate, but we're going to have to get, deep dive into something else, maybe. I mean, a lot of people are doing Karen Reed, I think, but that one is definitely one of those ones where the trial could probably be interesting because I've seen there's been a lot of controversy online and a lot of people with mixed feelings. So that could be one of those ones, like, who really knows what the turnout's going to be, like you're not really so, it's not open and shut. Oh, you want the couch? I like this couch. It's just not it's not that comfortable, but it is nice. Do a corpse flower plant. I think when I get another place and I have like an actual just room for the YouTube stuff, this couch would be perfect for it. And then in the living room, I want to actually get like a sectional, like a really comfy sectional. It does recline though. It has like recliners and it's pretty comfortable. I mean, The recline part is comfortable. To like lay on it, it's not that comfortable. Or if you have multiple people in the house, I just feel like you need a bigger couch type of thing. Like if you have guests or family and stuff like that. Tracy says she believes he's going to be let go. That's the thing. He's not death penalty qualified. I feel like that's another thing that could, I don't know, at the end, could it give Chad another out, you know? And they were talking about, like, I forgot what they called it, like some type of penalty specialist or whatever that they could bring on. But I think as much as it would hurt right now to have to, like, go get new attorneys, I mean, the delay, I don't know how long, it could be crazy. But to protect the overall integrity, they might have to get rid of this guy. I don't know. I don't know what they're going to do. It's a weird position that this attorney has put the judge in, the prosecution in, the case in. Do we have a trial tomorrow? No, I think tomorrow's open. I mean, I can look. Let me check out. There's this Discord page called Ask the Gavel Drops. Oh, they don't have anything for tomorrow. I don't see anything there. Tomorrow's open free for all. Oh, I gotta get out of here, I guess. Breaking the couch. Aurora says, if you only want to buy one couch for life, I recommend Lovesac. It's expensive as hell, but the washability and movement of pieces is awesome. I'll have to look it up and check it out. K-Pig says, I think it's going to be another, 2 to 5 years before the trial. Wow, we got a long way to go. So we have time to cover it. I've seen a lot of messy. I try not to get into messy stuff sometimes, but I mean, at the same time, there's so much conversation about it and there's a lot of interest, it seems like. Jamie, thank you for the 15, says, Mel, the FBI is investigating the investigation. Investigators of John O'Keefe's murder at the home of Brian Albert, a cop. There are many going to prison, and it ain't KR nor Turtle Boy. What I'll probably do on my own time is I'll probably watch some videos just to familiarize myself, and then maybe we'll talk about it sometime. It's just one of those things, too, that so many people have been already invested in watching. So, like, if I joined it, I'd have to know what I'm talking about. Damn, that couch, what the heck? It looks really nice. I see one for $5,200. Love seat. That looks really nice, though. I also see one for $18,000. Hell no. No, that ain't happening. I'd have to walk. Do they actually have stores you can walk into? I feel like I'd have to walk in and try it. Oh, they have a showroom locator. Let's see. Oh, they have one right by me, not far away. I'm not gonna buy a couch now, but once I move, I'd probably get a couch. I'd walk in just to try it, just to sit on the couch. I want to see what the hype is. Oh yeah, Cindy Crawford section. I heard is really good too. Yeah. Everybody. When am I coming to visit Dubai? I don't know. I mean, once I'm settled, I feel like I've been settling for years. Once I'm settled, my lease is coming up in a few months, I got to see what I do. Whether I get it, I'm probably leaning towards getting out of here. It's too pricey over here. I'm gonna be still probably in the same area, but like a little bit further down. I think it's a little bit cheaper. This place is just ridiculous, overpriced for what they offer. They don't really offer shit. The gate's never working. There's always problems over here. Yeah, no, 18K. That's crazy. Hell no, that shit better. Lifetime warranty, free cleaning every year or something. It better come with some stuff. It might be back. They're back. All right, let's get the chat cam. I might have to leave, but we'll see in a few minutes. Oh, they got 15, 20% off?
All right, we've confirmed the live stream's begun again. We are back on the record on case CR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor, and I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell, importantly, does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client. Although it may be difficult and he apparently will not be able to be compensated, it's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge. Thank you for your consideration.
All right. Thank you. Ms. Blake, any questions on the court's ruling? All right. Thanks, everyone, for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
If you want to talk about the agreement, it's for any
Santa Fe tow, we're on rotation.
Okay. Is it your car?
No, I'm in the truck. I didn't get hit or nothing.
Okay.
I just pulled over.
Gotcha. Are you hurt or anything?
My hands are a little bit from the
That's you, right?
Not my
Yeah,
car.
this
Yeah.
was me. I pulled over.
From the, I guess the airbag. I'm not too sure.
Okay.
Yeah.
Do you want me checked out? Just wiped up just in case?
Yeah.
How old are you?
I'm 40.
40. 5 1
Is it cool if I move my vehicle away and get ready so when Tracy sees it, we can load up and bounce?
Yeah.
All right, thank you, sir. I'm gonna back up, guys.
5 1 7
Okay. Yeah, go ahead. 517, good.
Can you roll 55 for a 40-year-old? Her left hand's a little banged up.
Are the others?
And your name?
Okay. Yeah.
And this your car?
This is my car.
Free to copy 28. Where's she at? Right here?
No. She's got two little girls with her, 2 little kids.
Over there?
Yeah, that's her.
And driver of what?
This car here.
Hi there.
Hi.
How are you?
Good.
Where are you going?
I'm going to my house.
Okay, your car's over there though. If your car's over there, why are you going here with your kids?
Well, I'm trying to get home.
Gotcha. Put the kids in your car. Walk over with me.
No, please.
Walk over with me.
No.
Hey, don't worry. Like, we're not taking them. We're taking it back to the scene.
No.
We are arresting them. All we doing is take them to the scene. Let's go.
No.
Let go.
No.
Let's go. Get up.
Why are you pulling me?
Get up.
I am getting up.
Ready? I'll help you up. Sorry, I didn't mean to pull you. Ready? 1, 2, 3, up. Don't worry. No, he'll take him over there.
No, my kids.
I promise you, ma'am. Don't.
I'm not resisting.
Well, just walk normal.
I am.
Okay. We'll talk over here. I promise you. You're really trying to drag your kids away. 1, 2. Were you driving this car? This is your car. Okay. So you and that car somehow made contact, right?
Yeah, I had a green light.
Okay.
And these people, they noticed I had a green light. I had the right to go.
Okay.
So.
Gotcha.
Look.
Gotcha. No. I'll talk to them. Okay. So you were heading westbound?
Yes, I was heading westbound to
Okay.
Fort Winds to go pick up my friend.
Gotcha. And then this car was going.
And then they slammed me.
This car was going northbound, right?
But they slammed me though.
Go ahead, sir. Gotcha. No, I totally get that.
Showing Class B, negative
10 for 29 correction, 28 of Boy Frank, Boy Young, 9-8. That's our vehicle. We'll need 246s. Okay.
Yes.
Why were you running away from the scene? If you got hit, why did you run away from the scene?
So scared.
What were you afraid of?
My point was because my kids got taken away from me when I wasn't doing nothing wrong.
Well, I'm not here to take your kids away. Okay, I'm here to investigate a crash, and then I hear, oh, the person involved is running, and I look, and you're basically dragging 2 little kids with you. Scared or not, is that the smart thing to do?
No.
Probably not, right? So don't worry, your kids. So you have to drag them back over here. We put them in a police car where they're nice and safe. We don't need kids out here running, right? Obviously, there was already one crash. We don't need another crash, possibly injuring your kids, do we?
Yeah.
Okay. So you're gonna run that way, and you don't live here, right? You live in.
Right over there.
Where do you live at?
At the hotel.
What hotel?
Hilton, right across from Fort Winds.
Okay. So, how much did you drink tonight?
Not that much.
Okay, what is not that much to you?
Not that much is like what? A pint and beer.
Okay, so a pint and a beer is what you had. When did you have?
I had enough to sober up. And then I was driving, I had a green light.
Gotcha. I'm not saying that you're at fault for the crash. I never said that. I was asking you how much you had to drink. So you said you had a pint and a beer. When did you have those?
2 hours ago.
Just so we're square, you did not hit your head.
No.
Do you have any major head injury?
No.
Did you graduate high school?
Yes.
Okay, college?
No.
Do you know the English alphabet?
Yes.
Do you know the English number system?
Yes.
Can you count backwards?
Yes.
Do you have any problems walking, balancing, or turning?
No.
Okay. Put your heel and toes together. Hands at your sides. And you know why we're doing this, right? Because you admitted to consuming alcohol.
Yes.
Okay?
I'm sorry, but my hair's in my way. Do you have a hair tie?
No, but you do it on your right wrist. Okay. Hands at your sides. See my finger right here? Yes or no?
Yes.
Follow my fingertip with your eyes only, without moving your head. This hand's gonna move from your left to your right. Just follow it the whole time. You understand what I want you to do?
Yes.
What do I want you to do?
You want me to look at your finger?
Okay.
And not move my head, only my eyes.
Yes. Here we go. Up. Ready? Follow it. I'll make it pretty easy for you, okay? I'm not a very good artist, but do you see that thing that should be a circle? Hands at your sides. Okay. Follow that circle with your eyes. Look at it the whole time. Okay? Right here.
Sorry, I'm concentrating on my phone.
Don't worry. Concentrate on my hands to your sides.
Sorry.
Concentrate on my finger. Okay, same thing, I'm gonna go up and down, just follow with the small finger. I notice that you don't have shoes on.
No, I don't.
Can you walk barefoot for 9 steps?
Yeah, I guess.
Okay, come over here.
No glass.
No, there's no glass. All the glass is over there. Come over here, sit right here on my light. Come over here. Put your heel and toes together. Face that way. Heels and toes together like this. Heels and toes. Hands on your sides. Okay. Can you imagine a straight line in between you and I?
Yes.
Okay, the line width will be the width of your foot, which is about 4 inches wide. Do you understand that?
4 inches?
4 inches wide.
How?
Roughly, the line will be the width of your foot, which is, your foot's about 4 inches wide. Can you imagine a straight line in between you and I?
Yes.
Okay, do me a favor. On that imaginary line, place your left foot just like this. Go and do it for me now? Nope, that's your right foot. Place your left foot. Okay, okay, now place your right foot directly in front of your left, just heel to toe like I'm doing. Go ahead and do it for me now. Right foot in front of left, hands on your sides. Up, don't start walking. End up in this position. Right foot in front of left. Nope. Right there. Hands on your sides. Do not move until I tell you to. Do you understand? Yes or no?
Yes.
Okay, get back in the position. Yep, Miss Chino, you have to stay in this position right here.
Yes.
Okay. Miss Chino, for that position, when I tell you to begin, and only when I tell you to begin, you'll take 9 heel-toe steps down the imaginary line. Get back in that position. Stay like that. Get in this position, like me. Okay, don't move. Okay, just like this. Don't start yet. No, don't start yet. Watch me. 1, 2, 3. Miss 3, you will take 9 steps. Once you make 9 steps, you will make a turn. Keep your front foot planted on the ground with your back foot, bringing it around like this, taking a series of small steps, turning all the way around. Get back in that position.
And then come back this way.
Get back in that position. Did you understand the turning process?
Yes.
Okay, after you
turn and then go like this.
Yep. Get back in that position.
Yes.
Right foot in front of left, stay like that. Right foot in front of left. Okay, don't move. Okay, Miss turn, you'll take 9 more steps down that same line, just like this. 1. Don't start yet. 2, 3. Back down to number 9. Get back in that position, the starting position. Right foot in front of left. Okay, in this test, keep your hands directly at your sides. Look down at your feet while you count, and count out loud so I can hear you. Also, once you start this test, don't stop until you've completed it, and don't forget to touch heel to toe in every single step. Any questions for me?
No.
Do you fully understand?
Yes, I understand, but I just gotta crash. So
I totally understand that. I totally understand that.
I don't want to mess up on the test.
Gotcha.
Because,
okay.
You know, I don't know. You see this shit right here.
Well, actually, that there's just a little teeny scratch and it looks like it's old.
No, that was.
Then again, I'm not a doctor, but I asked you if you had any major head injury. I asked you if you hit your head, and you told me no. Okay. Put your right foot in front of your left. Right foot in front of left. Okay. Next up will be step number 1. Go ahead and begin. Okay.
Round. 1, 2, 3, 4, 5, 6, 7, 8,
Okay. Face me.
Yes.
Heel and toes together.
Yes.
Hands on your sides. Right here. Next test called the one-leg stand. Okay, when I tell you to begin, what I want you to do is raise a leg of your choice, either your left leg or your right leg, approximately 6 inches parallel with the ground. Do you know what the word parallel means? Like level.
Yes.
Okay, let's say this is the ground. This
So that's like going like this.
No, not like that, but I will show you what I want. Okay, 6 inches roughly about the size of a Coke can. Watch me.
Officer, real quick, is it okay if we assess your children for injuries?
Yes, that's fine.
Okay, thank you.
Okay, mind my sides. Okay, don't start yet. Just watch me. What I'm gonna do is I'm gonna raise my left foot. Okay, don't start yet. My left foot is full extended. Both feet are straight. My foot's about 6 inches parallel with the ground, which means level. My hands on my sides. Once your foot is raised, look down at that foot and begin to count like this: 1001, 1002, 1003, 1004, 1005. Just keep on counting until I tell you to stop counting. Ma'am, during this test, keep your hands directly at your sides. Look down at the foot that's raised and count out loud so I can hear you. Any questions? No. You fully understand?
Yes.
Okay, you can start when you want. I'll tell you when to stop.
Well, what can I start?
Whenever you want. Ready?
Yes, I'm ready.
Go ahead, start. Begin.
1001, 1002, 1003. Oh shit. 1004, 2005, 2006.
I say stop counting. Keep counting.
Oh, sorry. I thought you said to count to 1000.
Just keep on counting until I tell you to stop. Keep going.
Sorry. Can I restart?
You want to test over?
Yes.
Ready? And let me reset this. And begin. Go ahead.
1001, 1002, 1003, 1004, 2005, 2006, 2007, 2008, 2007, 2009. I don't know. 2008, 2009, 2010, 2012, 2013, 2014, 2015, 2016, 2015.
Keep going, stop. Do you know the English alphabet?
Yes.
Okay, starting with the letter H, stopping at the letter R, recite them forward, but don't sing them. Say each letter clearly so I can hear you.
Recite between H and R, right?
Yes, go ahead.
J, K, L, M, N, O, P, Q, U. You tell me not to say R, right?
Is that what I said?
Yes.
Okay, I don't remember saying that, but okay.
Yes.
Can you count backwards?
Yes.
58 to 43 backwards. Start at 58, stop at 43. Backwards. Go ahead.
57, 56, 50, I'm sorry, 57, 56, 55, 54, 53, 53, 52, 51, 50, 49, 48, 40, 47, 46, 40, 45, 44, or 54, 52, 53, 50, sorry. I'm sorry, what did you say?
Okay, come over with me. Come over. One hand here, one hand there. Put both hands behind your back. Both hands. Both hands behind your back. Leave them there. I'll give you your phone here in a bit. Okay, I'm gonna put 2 cuffs on you, okay? Give me right now, I'm placing you under arrest, okay?
Step out for me. Who else in the vehicle?
Rebel.
Who else is in the vehicle?
Just him.
Just you two?
Yes, sir.
Okay, do you have your license on you?
Yes, sir.
Why are you going so fast?
Because I was trying to get to work.
Trying to get to work?
Yeah.
Where do you work at?
High Street.
Central High Street?
Yes.
Okay. Why are you pulling here then?
No, because I saw
Think
you.
you're losing me or what?
No, because I saw you and I was like,
You're doing 73 on Montgomery.
I'm sorry. I saw you. I swear to God, I saw you.
Okay. Whose car is this?
It's his car.
His car?
Yes,
okay.
sir. You want the registration insurance?
No, you're good. Where are you guys coming from right now?
Hold on. It's something loca. It's right there on Louisiana and Montgomery.
Loca. Ojos
Cantina.
Locos?
Cantina.
Ojos Locos.
No, Cantina.
Cantina?
Yeah, on Montgomery.
I don't know what that is.
It's, so you know where the gas station's at?
Montgomery what?
Louisiana.
Montgomery, Louisiana. I don't know.
It's kind of new. It's kind of new.
Is it?
Yeah,
Oh,
it's like
okay.
a little Mexican like type shit.
Okay. All right.
That's what
Yours?
Yes,
All right.
sir.
You say you're heading to work?
Yes.
Is that the truth?
Yes.
Okay.
And I've been drinking.
Yeah, I know you've been drinking.
Yes.
That's the second question.
Yes. That's
How
why
much
you're
alcohol?
like,
How
are
much
you
alcohol
sure?
you consume?
We had like 3 shots.
3 shots of what?
Yes. Tequila. Pasaron.
You drank 3 shots?
Yes, sir.
And he drank 3 shots?
He drank more.
He drank more.
This is his car. I'm driving.
Okay. All right.
Like, and I told him that I could get a room because obviously I work at a hotel.
Okay. All right. So you're doing 73 on Montgomery.
Yes, sir.
Okay. And you're speeding down
Yes,
here
sir. I
trying to lose
saw
me.
you and I was like, ah!
Okay. I'm gonna make sure you're safe to drive.
Okay. Yes.
Okay. All right.
You could,
I
I just can't wear these shoes because they're big
That's
as
fine.
fuck.
All right. No big
Like,
deal.
if you need
Just hang
it.
tight, okay?
Okay, cool.
See how your head straight right there is? Just keep it straight, okay? See the tip of my finger?
Okay.
Follow that with your eyes only, okay? Keep your head down.
I-40
Right there.
West, so 160, out with a white and Dakota Honda, 28.
Direct westbound 160.
Sorry, my eyes are getting dry because my eyelashes.
You can blink.
Okay.
It's
cool.
okay for you to
Like,
blink.
my eyes are getting dry.
It's okay for you to blink.
45
Okay?
17.
Go ahead.
Do you want me to go to 47? Stand by.
Keep your head down. Right there.
No.
Sorry, my eyes are
You can
dry.
It's okay for you to blink,
Okay,
okay?
I'm sorry. I already know how that works. It's like jittery, and I'm like, ugh, okay.
It's
Sorry.
okay. Just keep your eyes open. It's okay for you to blink, okay?
Alright.
Over here. Over here. There.
I fucked up. Honestly.
Oh, you're good. You're doing good.
No, I'm not lying.
Keep your
Sorry, I
head. Keep
fucked
your hands
up.
down to your side.
Sorry.
What the hell are we watching? I'm sorry, bros. I had to go pick up the baby. A video started auto-playing. Gotta stay focused, man. Don't lose focus now. Follow the finger. I feel this shit sober, to be honest with you.
And I'm cold as fuck. I'm sorry. I'm cold.
Don't laugh too much now.
My eyelashes. I'm sorry. I cannot see.
As far as you can.
Okay.
Eyelashes. You're doing good so far. What y'all think? What would you give her a grade? You're doing good so far. I wouldn't be giggling so much, but
okay. Put your
ridiculous.
back on.
The hell is she wearing?
Sandals back on.
I'm sorry. If I had my eyelashes
Or just like a
off,
top.
I could take them off if you want me to.
Oh, you're good. All right. Just hang behind your vehicle.
What's she doing? Was she sitting in her car when he came up?
Just hang tight right there. Don't grab anything. Just stand there, okay?
I'm like, can you at least
Just give me a sec. Yeah, just give me a second, okay? Give me a second.
She giggling too. Oh, Lord. Giggling way too much.
I said, yeah.
Girls gone wild.
Yeah, good.
F? C minus?
Let's walk over here.
E for stupid.
I'm like, this is the officer.
Oh, speeding.
Like,
Way
this
too
is the officer. Mommy.
She's FaceTiming mom?
So just letting you know, because I told him I need to call you. So just letting you know, okay?
What the hell happened?
I was going 73 on a
35.
35.
You should have pre-signed to be here on time.
Well, okay, listen, I'm just calling you to let you know, okay? Love you, bye.
Yeah, she don't want to hear mama's.
Put your phone right here for me. Right. Wait, you want to put it back in your purse? I don't want that to slide. Or somebody to grab it. No? Okay, walk over here for me. See where my leg is? Stand right there for me. All right. Right there. Face that way for me.
Oh, she made it to 3 tequila shots? Man.
All right, put your feet together.
Can I take off my shoes?
Yeah, you can take off your shoes.
Well, because these are really big.
All right, put your feet together. Hands down to your side. You say you have no major injuries from your legs? No. You can walk, balance, turn?
Well, I have like arthritis, but that's about it.
But can you walk, balance, turn? Okay. All right. Can you imagine a straight line in front of you?
If there's a straight line here for me, can I walk on that straight line?
Well, I can't do it because of the unit. Okay. Well, can you imagine? Can you imagine a straight line in front of you?
Yeah.
About just straight.
Okay.
Okay. I'm gonna have you put your left foot on that line, and then put your right foot in front of your left foot, touching heel to toe. Touching heel to toe. Okay. Miss, ma'am.
Yeah.
I didn't say walk.
Oh, sorry.
You're good.
I thought you were
Just,
like,
just follow my instructions. Okay. Can you imagine a straight line in front of you?
Yes.
About the width of your foot?
Yeah.
Okay. Put your left foot in front of you, and then put your right foot in front of your left foot, touching heel to toe.
Sorry, no.
Okay.
Sorry. Oh my god. Okay.
Just follow my instructions, okay?
Sorry.
All right. So put your right foot in front of your left foot. Put your right foot in front of your left foot. Right there. And hands down to your side. Cheers. I didn't say walk.
Oh, I'm sorry.
Just follow my instructions.
Okay, that's okay. Sorry.
Okay.
Go.
Put your feet together. Okay, now just follow my instructions, okay? I'm going to give you detailed instructions. Okay? Put your right foot in front of your left foot. Touching heel to toe. Right there. Hands down to your side. And you're going to stay in that position until I tell you to move. Okay? On this imaginary line about the width of your foot, you're going to walk 9 steps forward, touching heel to toe on every step, looking at your toes the entire time, keeping your hands and arms down to your side at all times, and count out loud for me in every step.
Yes, sir.
Okay? Once you get on your 9th step, leave that forward foot planted in the ground. With your back foot, you're going to take a series of small steps, and you're going to turn around.
Okay.
And do 9 steps back, touching heel to toe, looking at your toes the whole time, keeping your hands and arms down to your side at all times, and count out loud for me in every step.
Yes, sir.
Do you understand that?
Yes, sir.
Okay. All right. Stay in that position until I tell you to move. Okay? So we're in this position, right? I'm going to show you the test.
Oh, this sir.
Stay in that position. Put your right foot in front of your left foot. Put your right foot right there. I'm going to show you the test, okay? So we're in this position, right?
Yes.
So what I'm going to have you do is you're going to go 1, 2, 3. I only demonstrated 3, but you're going to do 9. Yes, okay? Once you get on your 9th step, leave that forward foot planted on the ground.
Do you want to put my hands on my back?
Put them down to your side.
I can't.
Okay? And then with your back foot, take a series of small steps.
Okay.
Turn around and do 9 steps back.
Okay.
Okay? 1, 2, 3. Okay? Touching heel to toe on every step. Looking at your toes the whole time. Keep your hands and arms down to your side at all times. And count out loud for me in every step. Do you understand that? Okay, do you have any questions? Okay. Put your right foot in front of your left foot.
1.
Okay. No, up. Go back.
I'm sorry. So you said.
You're good. Put your right foot in front of your left foot. Okay, that's going to be the starting position, okay? Do you have any questions?
No, sir.
Do you understand the test?
Yes,
It's
sir.
very important, Ms. Once you start the test, do not
sir.
stop until you're done.
I understand. I'm recording.
Okay, you may begin.
1, 2, 3, 4.
Okay, I see you, Pepper.
6, 7, 8.
Oh, wrong camera.
Sorry, I already failed it.
You can turn around. Start from there. Turn around.
Yeah, she's twirling.
And do nice as back.
1, 2, 3, 4, 5.
All right, I see you.
7, 8, 9.
Put your...
I'm like, at first I was
stand over here for me.
I'm like,
Right there. Stand right there for me. Face me.
Yes, sir.
Face me in the picture. Put your feet together. Hands down to your side. All right, Mr. You're going to lift one leg of your choice. Your right or left leg. It doesn't matter to me. Okay? Approximately 6 inches off the ground. Okay? Both legs are going to be straight.
Count to 10.
Your foot's going to be parallel to the ground. Parallel means level to the floor. Your hands and arms are going to be down to your side at all times. You're going to be looking at that raised foot and count out loud in a series of 1,001, 1,002, 1,003. And you're going to keep going until I tell you to stop.
Okay.
Do you understand that?
Yes, sir.
Okay. I'm going to go and demonstrate it for you. Okay?
I can't. Sounds so, sir.
Put your feet together. Okay. Face that way for me. Right there. All right. I'm going to go and demonstrate it for you. Okay? So we're in this position, right?
Yes, sir.
So lift the leg of your choice. Okay? Approximately 6 inches off. Watch me.
Okay.
Watch me. Watch me. Approximately 6 inches off the ground. Your hands and arms are going to be down to your side. Both legs are going to be straight. Your foot's going to be level to the floor. You're going to be looking at that raised foot, and you're going to count out loud. 1,001, 1,002, 1,003, 1,004, and you're going to keep going until I tell you stop. I didn't tell you to start. You're good. Good. Just follow my instructions. Okay. Do you understand the test?
Yes, sir.
Do you have any questions?
No, sir.
Okay. It's very important. Once you start it, do not stop until you're done.
Yes, sir.
Or until I tell you to stop.
Okay.
Do you understand that?
Yeah.
Okay. I'll let
I
you
had
know
to
when
check
to
if this was like playing fast because he's talking so fucking. I would like step back and slow down for saying like, yo, this chick is. I don't know how often. I mean, how much do they have to keep pushing the sobriety test if clearly she's not sober?
All right, Miss. You may begin when you're ready.
2001, 2002, 2003, 2004, 2005, 2006, 2007, 2008, 2009, 2010, 2011, 2012, 2013.
She got a leg up or something?
2015, 2016, 2017.
Keep going.
Sorry, I can't.
Keep going.
I lose balance. Is there another test I can do?
Yeah, of course. Do you want to stop this one?
Yes.
Yeah, put your sandals back on.
Yeah, test the cop
right.
too. Make him do a
We're ready
sobriety
to
test.
some other tests, okay? You're not gonna be able to walk, bounce, or nothing like that, okay? We're gonna stand in front of my vehicle. Just don't touch my vehicle or lean on my vehicle, okay?
I gotta go. Just no, it's right there.
You're good. Face me, Mr. All right.
She
You said, how old are you, 24?
Yes, sir.
What's your highest level of education?
12.
So you graduated?
Done right there.
You graduated from high school? Yeah. Okay. Do you know your numbers from 0 to 100?
Yes.
Do you know your English alphabetical letters?
Yes.
From A through Z?
Yes.
Okay. I'm going to have you recite a certain amount of numbers.
Not backwards.
No. I'm going to explain it to you. Okay. I'm going to have you recite a certain amount of numbers and a certain amount of letters. Okay. The numbers are going to be backwards. The alphabetical letters are going to be forward. Okay. I can't even recite them, the alphabetical letters backwards.
I've seen this. Okay. I cannot do backwards.
Okay. So you're going to start at the number 57. Okay. Start at 57. Yeah. Count backwards to 30 and stop. Okay, start at 57, count backwards to 38 and stop. Do you understand that?
Yes.
Okay, can you do it?
I think.
Okay, you want to try it?
Yeah.
Okay, 57, count backwards to 38 and stop. Do you understand that? Do you have any questions? Okay, you may begin.
56, 55, 54, 53, 52, 51, 50, 48, 47, 46, 46, 45, 44, 43, 42, 41, 40, 49 or 39, 38, 37, 36, 35. You
gotta stop now, right? You gotta stop. You're supposed to stop somewhere.
You done?
I'm starting cold. Yeah.
You good? Okay. In your English alphabet. Okay.
Is this Texas? I got a feeling like this is Texas. All my exes live in Texas. I don't know how long this body cam was, but it does look cold out there.
Have you recite it backwards? You're gonna recite it forward.
Okay.
Okay. You're gonna start at the letter H. And you're going to recite every alphabetical letter forward to the letter R. Do not sing the alphabet. Just recite every letter out loud so I can hear you. Start at H.
H-I-J-K-L-O-P-K-R.
Done?
Yes.
Okay. And then what's your dominant hand?
Right.
Your right hand? Okay, watch me. Don't start the test. Okay, you're going to start with your pinky and your thumb. Don't start it. Just watch me. Okay, start with your pinky and your thumb. You're going to touch your index fingers. Okay, you're going to go 1, 2, 3, 4. 4.
Okay.
4, 3, 2, 1. That's one pass.
Yes, sir.
I need it 3 times. I'm going to show you that. Okay. 1, 2, 4. 4, 3, 2, 1.
Okay.
That's one pass. 3 times. Do you understand that?
Yes, sir.
Do you have any questions?
No, sir.
Okay. You may begin.
4, 3, 2, 1. 4, 3, 2, 1. 4, 3, 2, 1.
Okay. All right. Just put your vehicle for me.
Yes, sir.
Okay. Try to bend it back for me. Just put your hands for me.
What? No! No!
All right, Miss. It is 12:23 a.m. Okay, you are going to be placed under arrest for driving under the influence of intoxicated liquor and/or drugs. Okay, I don't see any pockets on you. Do you have anything that you're concealing?
Yes, sir. Just in my purse.
In your purse?
Yes.
What do you have in your purse?
No, not concealing. Just in my purse. It's just my purse and my phone.
Oh, okay. No, I'm saying on your person.
Oh, no.
Okay, you have nothing in your shirt, inside your pants, or anything that I should know of. No? Okay. All right, sit down right here for me.
Sit down?
Yeah, right there. Oh, you know what? It's pretty cold. Walk over here.
It's okay.
Walk over here. I'm gonna put you back here. Yeah.
My phone. Don't forget my phone.
No, I don't. I will never forget your phone.
Like my phone's expected.
Okay, over here. Have a seat for me.
Move my hair.
Yeah.
Honestly, please, like, like.
That's pretty wild for 3 shots.
More, like on my face.
Oh, on your face.
Yes.
It's been on 4 hours. Holy crap!
Got more hair.
No. Sorry, on my other side.
Like, put Texas down.
There. Okay.
Oh no.
I'll fix it for you. Let me put your seatbelt. Okay.
How you doing, ma'am?
That's it. All right. I don't want to play the whole video because I already was away and there's playing video. So, but all right. Thank you guys so much for coming today. Let me get the super chat that I missed. I did miss a super chat. I was away picking up the baby. Dem Bananas. If I'm saying that right. DM Bananas. Thank you so much for this 20. Says Mel, will you be following Chad Dorman? Oh, I don't know why I read Chad Daybell. Chad Dorman. That's the guy that went and shot his family, right? Or something like that. I think I covered it one time. What did that guy do? He did some despicable shit. Chad Doorman, father accused of killing 3 sons. Ah, yeah. When is that happening? Let me see when the trial. Wait, did you say? Oh, in July. Yeah, I'd be open to it. I don't know what's happening. You know, I barely know what's happening tomorrow, but I have been marking down. Like I've been telling people, I got my big calendar. I've been marking down dates so we're a little bit more organized. So, you know, we'll see what's coming up. Because this next week, I don't have anything marked on the calendar. But the week after, January 29th, we got Alex Murdoch for 3 days. And we have the Womb Raider, Marlon Ochoa, that week too. And then we have February 6th, Adam Montgomery. And I don't know. We'll see. Did Delphi Court ever come back? Let me take a look real quick. I don't think they ever did come back, but let me look to see if there's any kind of update before we get off. Daybell. I wasn't expecting to be on all day today, like 4 hours, but it was still cool. It was chill. One of the reasons because I had it. That's what I'm gonna do now. I'm gonna work on a little project. I got the second computer, the old computer I was streaming from. I got it booted back up, and I built a desk yesterday. So I'm gonna have another little area with a computer area that can be used. And so I just need to install some apps and kind of like the computer's so dirty and dusty. I'll show you guys. I'm gonna take it outside, take air cans and like clean it out really nice. Install some really basic bare minimum apps on there. Maddie can use it too if she needs to for school stuff. Okay, for Daybell, we know that judge denied it, but for Richard Allen, I don't know if he's deciding today. That's going to be another day. Hold on. Richard Allen. I'm really curious to know what's going to happen with that. Okay, let's see. Let's look at these 2 articles. I'll share it with you on the screen. But yeah, it was cool hanging out today. I know some people have been saying they wanted to hang out for the day. Indiana Supreme Court mulls decision after hearing arguments in Delphi case. I don't like this look on the screen. Hold on. Okay. Okay. After hearing all the arguments, the high court adjourned to discuss the case and said the court would come to a decision as soon as possible. Damn, so they didn't even give us a date. Oh. I guess we'll just have to stay posted on it and wait. Court TV just went live. You can hear them talking in the courtroom. Oh, that's probably for Karen Reed. Oh, no, they're talking about Richard Allen. Oh, wait, is this from earlier?
Absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client.
What Court TV is doing, they're showing the old video. This is from, they're premiering it. They're premiering what we watched earlier. They're re-premiering it. So this, we already saw this.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the 3 violations of the Sixth Amendment provide this constitutes 3 situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
All right. So I'm going to take I need to take a few minutes. Court TV is doing Karen Reed. I don't know if you guys want to come back in like 20 minutes and watch the Karen Reed hearing. Actually, in 10 minutes. I just need to get Maddie settled with some snacks. I think she grabbed something, but I need to go make sure she has something. Karen Reed. The case is scheduled to trial March 12th. Might not be bad to take a look at it. You want to come back in a few minutes, 10 minutes? Maybe we can cover that in March. I don't think we have anything scheduled for March. Let me create a new stream. Create new stream. Go live. I don't know how long the hearing's going to be, but Karen Reed hearing. Murder. Okay. I'm going to set it for, I might launch it earlier, but I'm going to set it for 3. I wonder if they're really actually starting at 2:50. I'm going to set it for 3, but if they come on earlier, I'll just start it earlier, okay? What Jules says, so baby girl, not full day of school, or does she start earlier than? Yeah, no, she starts at 8 in the morning. 8 in the morning. So yeah, this is a full day. It's already past 2 o'clock over here. And tomorrow's a half a day, so I'll have to pick her up early tomorrow. Okay, so Karen Reed. Blah, blah, blah. Okay. All right, so we'll do this Karen Reed hearing. I'm going to transfer everybody over. Let me make sure I put on closed captions. And I'll be back in a few minutes, like 10 minutes or so. All right. See you guys in a bit. Love you. All right. Bloop, 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 bloop.